Before you woke up this morning, the Supreme Court changed how your rights work. No warning, no headlines, no debate. And once you understand what they did, you'll realize America is not legally the same country it was yesterday. This is where everything breaks apart. This is the moment your zip code becomes more powerful than the Constitution. What happens next is why lawyers are calling this a legal earthquake. This is no longer theory, this is already happening. If you believe Americans should know when their rights are changing, subscribe. If you believe justice should be equal everywhere, share this. And if you think this ruling protects freedom or destroys it, tell us why in the comments. The first thing people will notice is silence. Not the dramatic kind, not the kind that comes after an explosion, but the quiet confusion that follows a sudden rule change. No alarms go off, no push notifications explain what just happened. Life continues as usual, while the structure underneath it has been rebuilt. In courtrooms this morning, judges opened their dockets, knowing that the authority they relied on for decades is no longer available to them. Clerks printed out new guidance. Attorneys whispered to each other in hallways, trying to understand which of their cases just became weaker and which suddenly became stronger. Some lawsuits that once had nationwide impact were reduced overnight to something much smaller, something local, something limited. A federal judge in one state can no longer pause a policy for the entire country. That judge can only protect the people who came to that courtroom and put their names on the paperwork. Everyone else, even if affected by the same law, must fend for themselves. This means that the idea of a single constitutional standard, applied equally at the same time, has just been replaced with something more fragmented. The Constitution still exists. Federal law still exists. But enforcement now travels by geography. In one city, a policy is blocked. In another, it is active. In one courtroom, rights are protected. In another, they are not yet recognized. Not because the Constitution changed, but because procedure did. This is why legal scholars are calling this a shift in power, not just a shift in process. Power now moves away from judges who could stop government action at scale and toward the executive branch, which can enforce policies immediately unless and until each affected person fights back individually. For decades, nationwide injunctions worked like emergency brakes. When something appeared unconstitutional, a judge could stop the entire train before it ran over millions of people. Now, the brakes only stop the train for the few people standing directly on the tracks in that courtroom. Everyone else is expected to run their own race to catch up. Immigration is the fastest moving battlefield because enforcement operates in real time. There are no delays, no buffers, no waiting periods once authority is restored. Policies that were frozen can begin again almost immediately, and they can be enforced differently from district to district. Conflicts will multiply, appeals will stack. The Supreme Court will be asked to step in again and again just to resolve contradictions that never had to exist before. That means more delay, more confusion, and more instability. And while lawyers fight, the public lives under uncertainty. Can this policy be enforced here? Is it blocked there? Does it apply to me or not yet? The law becomes something you have to look up by location, not by principle. Businesses are already modeling this. They are preparing for a country where federal compliance varies by district. A company operating in 5 states may need 5 legal strategies, 5 enforcement standards, 5 sets of risk calculations. This is not how federal law was designed to function. Federal law was created to be uniform, predictable, equal across state lines. That predictability is now broken. Civil rights attorneys are especially alarmed because nationwide injunctions were the primary tool for stopping systemic harm. Discrimination rarely affects just one person. It affects classes of people, communities, entire populations. The ability to halt that harm broadly is what gave constitutional rights real power. Now protection becomes piecemeal. One student protected, another not. One worker protected, another not. One family protected, another not. All under the same constitution. Supporters of the ruling say this is how the system was always supposed to work, that courts exist to resolve disputes, not to govern the country, that judges should not act as nationwide policymakers, that elections, not injunctions, should shape public policy. Opponents say that without broad judicial protection, unconstitutional actions can survive long enough to become reality for millions before the courts ever catch up. This is not a technical disagreement. This is a disagreement about what justice means in real time. Is justice something that exists only after you file paperwork, or is it something that exists the moment a law violates your rights? That question now defines American law. Two families with the same legal status, living in two different states, can now face entirely different outcomes. One protected, one exposed, one able to pause enforcement, one unable to slow anything down. That is not theoretical, that is procedural reality. The same thing applies to voting rights. If a voting restriction is challenged and blocked in one district, it remains active everywhere else until someone else files another case and convinces another judge. That takes time, that takes money, that takes legal expertise, and elections do not wait. So the question becomes simple and brutal. How many people can realistically afford to protect their own rights one lawsuit at a time? This is where the ruling stops being about courts and starts being about access to justice. Large organizations with legal departments can adapt. State governments can adapt. Corporations can adapt. Ordinary people cannot adapt at the same speed. This is why critics are warning that constitutional protection may now follow wealth, organization, and political power rather than citizenship alone. If you can fund litigation, you can defend yourself. If you cannot, you may be subject to policies that a judge has already ruled unconstitutional in another part of the country. That creates two Americas under one constitution, one with protection, one waiting for it. Inside federal agencies, this ruling is being read as a green light, not because agencies want chaos, but because uncertainty now works in their favor. Enforcement can proceed unless directly stopped in a specific case. The default has flipped. Before the default was pause. Now the default is proceed. That alone changes how policy is written, how aggressively it is enforced, how fast it moves. It also changes how politicians govern. A policy that might once have been blocked nationwide by a single judge now faces only localized resistance. That makes bold executive action less risky and far more attractive. And that is why this decision is being described as a realignment of power, not left versus right, not conservative versus liberal, but centralized restraint versus. Some will hesitate to rule boldly, knowing their decision has limited effect. Others will write opinions that openly challenge the new framework, hoping higher courts intervene. The system becomes internally conflicted. Meanwhile, politicians will exploit the delay. A policy that survives long enough often becomes normalized. Even if later struck down, the damage may already be done. Elections may pass. People may move. Families may be separated. Businesses may adapt. Harm becomes history before courts finish their work. This is why emergency rulings matter. They shape reality before debate can. And this ruling came without the public conversation that usually surrounds decisions of this magnitude. No arguments broadcast, no national countdown, no warning, just a line of text that rewrote how power flows. The public will not feel it all at once. It will arrive in pieces. One story about an immigrant affected differently. One story about a voting rule enforced here but not there. One story about a healthcare regulation suddenly active in one region. Slowly, a pattern will emerge. People will start asking the same question over and over. How can both of these be legal? And the answer will always be the same. Because courts no longer protect everyone at once. They protect only who is standing in front of them. This transforms the Constitution from a shield into a tool you must know how to use, must be able to afford to use, and must be brave enough to use publicly. That is a profound shift. In the past, nationwide injunctions created uniform pauses. They gave the country breathing room, time to debate, time to appeal, time to think. Now policy moves first, courts chase second, speed beats certainty, and speed always favors power. This is why legal historians are comparing this moment to earlier shifts in American law, moments when procedure quietly reshaped reality, more than any statute ever did. Because laws define what is allowed, procedure defines who can stop it. And now stopping it is much harder. The Supreme Court says this returns judges to their proper role. Critics say it removes their most important function, preventing widespread harm before it becomes irreversible. Both sides agree on one thing: the system will never operate the same way again. What comes next is a legal arms race. Advocacy groups are preparing mass filing strategies. Instead of one case, they will file dozens simultaneously in different jurisdictions. hoping to create overlapping protections that mimic the old nationwide effect. That requires enormous funding. Only the largest organizations can attempt it. Smaller groups will be left behind. Individual citizens will be left behind. Justice becomes a matter of scale, and scale is not evenly distributed. This is how procedural changes reshape society. Not loudly, not instantly, but permanently. By the time people realize what has changed, they will already be living inside it. The Supreme Court did not announce a new rule for America. It announced a new reality, one where rights are no longer paused by principle, but negotiated by presence, funded by resources, and enforced by geography. And once a system moves in that direction, it rarely moves back without crisis. The real danger is not what happens in one courtroom. It is what happens when thousands of courtrooms start operating under different realities at the same time. Law becomes fragmented, and fragmentation creates power vacuums. Power vacuums are always filled, not by ordinary people, but by institutions that move faster and have deeper resources. For the executive branch, this ruling is freedom of motion. Policies can now roll forward unless stopped in each specific jurisdiction. That means enforcement can begin immediately in most of the country, even if a judge somewhere has already found serious constitutional problems. The government does not have to wait for national clarity. It only has to wait for local resistance. That changes how risk is calculated. Before, a single lawsuit could halt everything. Now lawsuits slow things down only in isolated pockets. The incentive shifts towards speed. Act first. Enforce first. Let the courts catch up later. And courts are slow. They require filings, hearings, evidence, appeals, months of waiting, sometimes years. Rights, however, can be violated in minutes. This is why civil rights lawyers are using words like exposure and vulnerability. Not because rights disappeared, but because the shield that once covered everyone now only covers the people who can reach it. In practice, this means legal geography will become as important as legal principle. Where you live will matter more than what the Constitution says. A person in one district may be protected from a policy that a person in the next district is fully subject to. The difference is not legality. The difference is procedure. And procedure is invisible to most people until it hits them personally. Imagine applying for something and being told, that rule doesn't apply to you here. Then watching someone else in another state be told, that rule absolutely applies to you. Both answers are legally correct at the same time. That is not stability. That is controlled chaos. Federal judges now face a dilemma. If they believe a policy is unconstitutional, they must still allow it to continue affecting millions while protecting only the plaintiffs before them. That is not how judges were trained to think. Courts are meant to prevent harm, not just acknowledge it. This creates moral pressure inside the judiciary. Judges must now accept that injustice can continue elsewhere, even if they are convinced it is real. That changes the psychology of judging. Another layer most people have not yet considered is how this changes trust in the legal system itself. Courts work because people believe that when a judge speaks, the law applies equally to everyone. That belief is the glue holding the system together. When enforcement becomes uneven, trust becomes uneven too. When people see different outcomes for the same issue, they stop asking what does the law say and start asking who has power here. That is a dangerous shift. Law becomes less about justice and more about positioning. This is how legal systems slowly lose legitimacy, not through one dramatic collapse, but through small inconsistencies that pile up until people stop believing in fairness altogether. And fairness is the foundation of obedience. People follow the law because they believe it treats them equally. When that belief erodes, compliance turns into resentment. Already, community legal aid groups are reporting a spike in calls from confused citizens. People are asking whether a rule applies to them, whether they are protected, whether a decision in another state means anything where they live. These are not political questions, they are survival questions. They reveal something deeper. Americans are now expected to understand jurisdiction the way lawyers do. That was never the design of a democratic legal system. The law was supposed to be simple enough that an ordinary person could rely on it without a legal team. Another layer most people have not yet considered is how this changes trust in the legal system itself. Courts work because people believe that when a judge speaks, the law applies equally to everyone. That belief is the glue holding the system together. When enforcement becomes uneven, trust becomes uneven too. When people see different outcomes for the same issue, they stop asking, "What does the law say?" and start asking, "Who has power here?" That is a dangerous shift. Law becomes less about justice and more about positioning. This is how legal systems slowly lose legitimacy, not through one dramatic collapse, but through small inconsistencies that pile up until people stop believing in fairness altogether. And fairness is the foundation of obedience. People follow the law because they believe it treats them equally. When that belief erodes, compliance turns into resentment. Already, community legal aid groups are reporting a spike in calls from confused citizens. People are asking whether a rule applies to them, whether they are protected, whether a decision in another state means anything where they live. These are not political questions, they are survival questions. They reveal something deeper. Americans are now expected to understand jurisdiction the way lawyers do. That was never the design of a democratic legal system. The law was supposed to be simple enough that an ordinary person could rely on it without a legal team. Now even lawyers are unsure how fast protections will shift. Inside Congress, reactions are mixed. Some lawmakers see this as an opportunity to push aggressive policies without fear of instant nationwide shutdown. Others see it as a threat to legislative authority itself, because judicial fragmentation makes federal law unpredictable. When federal law becomes unpredictable, state power rises. States will begin to shape reality more than Congress does. Enforcement will depend on local court dynamics. State attorneys general will become. History shows what happens when that model takes hold. It deepens inequality. It entrenches regional power. It turns national debates into territorial battles. That is why civil rights leaders are especially alarmed. They remember a time when constitutional rights existed on paper, but not in practice in large parts of the country. It took nationwide enforcement to change that reality. Now enforcement is once again conditional, not on morality, not on legality, but on access. And access has always been uneven. Another quiet effect will be exhaustion. Lawsuits take energy, activism takes energy, constant legal defense wears people down. When protection requires continuous action, fewer people can sustain it. That benefits the side that never gets tired. Institutional power. Governments do not fatigue. Agencies do not burn out. Policies do not need rest. People do. This creates an imbalance that compounds over time. Even when citizens are legally correct, they may be practically defeated. That is the difference between having rights and being able to use them. The ruling does not erase rights. It increases the cost of defending them, and cost determines access. This is why legal experts say this decision shifts America closer to a permission-based system of justice, where protection must be activated rather than assumed. Before, the burden was on the government to justify enforcement. Now the burden is on the citizen to stop it. That is a reversal of posture. It may seem subtle, but subtle shifts create permanent outcomes. In the coming months, stories will begin to surface. Not dramatic headlines at first. Small stories, a school district enforcing a rule that is blocked elsewhere, a hospital following regulations that another region cannot, a business facing fines in one state while competitors are exempt in another. Each story will feel isolated. Together they will form not by intention perhaps, but by consequence. And consequences shape reality more than intentions ever do. So when people ask what changed, the answer will not be found in legal textbooks. It will be found in it shifted the experience of being an American from shared protection to conditional protection. And conditional systems always divide people into categories. Those who know how to navigate it, those who can afford to navigate it, and those who are trapped inside it. That is the structure that now exists. Not because anyone voted for it, not because Congress debated it, but because procedure was rewritten in silence. And silence is where the most powerful changes are made. In the end, history will not remember the technical language of the ruling. It will remember what life felt like after it. Whether people felt more secure or more exposed, whether justice felt closer or farther away, whether the law felt like a promise or a maze. Because law is not experienced in court opinions, it is experienced in moments of vulnerability. When someone is stopped, when someone is denied, when someone is afraid, when someone is told, There is nothing we can do for you here. Those moments will now happen more often before protection arrives. And once people experience that, their relationship with the legal system changes permanently. They stop seeing it as a shield. They start seeing it as a battlefield where preparation matters, where resources matter, where timing matters, where location matters, and where not everyone is equipped to survive. This ruling did not remove the Constitution. It removed the assumption that the Constitution protects everyone at the same time. From now on, protection must be claimed. It must be fought for. It must be activated. That transforms citizenship itself. Citizenship was supposed to mean guaranteed rights. Now it increasingly means potential rights, depending on your ability to access the system. That is a philosophical shift, as much as a legal one. It moves America. This is not the end of a legal doctrine. It is the beginning of a different legal culture. One where the courtroom becomes a gate, not a shield. One where justice is no longer automatic, but activated. One where power flows faster than protection. And once a system learns to move that way, it rarely returns to stillness. What makes this moment so dangerous is not only what has changed, but how quietly it changed. There was no national conversation, no preparation, no warning to the public that the structure of legal protection was about to shift. The country went to sleep under one system and woke up under another. Most Americans still believe that if something is unconstitutional, it is automatically stopped everywhere. That belief is now outdated. And until people understand that, they will walk into situations thinking they are protected when they are not. That gap between belief and reality is where harm happens, because when citizens act on rights they think are secure and discover they are not, trust collapses instantly. Confusion turns into fear, fear turns into anger, and anger, once it spreads, becomes instability. This is how legal changes become social changes. In law schools, professors are already rewriting curriculum. Decades of doctrine just became obsolete. Students are being taught that national impact litigation is no longer a reliable strategy. The future belongs to mass localized litigation or political solutions, not judicial shortcuts. That alone tells you how deep this goes. When education changes, the system itself is acknowledging permanence. Advocacy organizations are also being forced to redefine their missions. They were built to protect many people with one case. Now they must choose who to protect first, who to prioritize, and who must wait. That is not a legal question. That is an ethical one. Who deserves protection sooner? Who can wait? Who can be asked to risk harm while the system catches up?